So let's get started. My name is Tim Sandefur. I'm the Vice President for Legal Affairs here at the Goldwater Institute. And joining me for this Supreme Court roundup is Jon Riches, our Vice President for Litigation. Thanks for coming back, Jon. I'm glad that you decided that it was worth another shot. Maybe this time we'll get it right.
Well, it's always a joy to speak with you about the court and all things constitutional.
So I wanted to start off the first case that we talk about today. Now, before I start, I should mention that we're happy to answer your questions. You just type them into our chat box, and we'll be monitoring them as we talk about the cases from this term, and then we'll get to answering them at the end, or we'll work it in if something comes up. So don't forget to write in your questions in our chat box as we go forward. Let's start with the first case that we wanted to talk about today, which is a case that's of particular importance to those of us in the Western states, but of course it was a big deal nationwide, obviously, and that is Johnson versus Grants Pass. This is the case involving homelessness, and it comes actually at the end of something that's been going on for several years, where the Ninth Circuit Court of Appeals decided a case called Martin versus City of Boise, well, more than 5 years ago now, I think, in which the court said that it was cruel and unusual punishment to arrest people for sleeping on sidewalks or in public parks unless the government provided the people with a shelter bed. Now, it's important to say it has to be a government-provided shelter bed, according to the Ninth Circuit, because if you count church-operated homelessness shelters, the Ninth Circuit said that violated the First Amendment's Establishment Clause. Now, of course, that's a real problem because churches are probably the most common source of aid for the homeless. So to rule those out and then say, okay, now what you do is you take the total number of shelter beds in government-run homelessness shelters and then subtract the total homeless population. And if the number is negative, then you're not allowed to arrest people for sleeping indefinitely in public parks or on public sidewalks and so forth. Well, that really loads the dice. And on top of that, it's really illogical to say that it's cruel and unusual punishment to arrest a person because they couldn't possibly help sleeping in a public park or on a sidewalk unless the government provided them with an alternative is illogical. By that logic, if I go to a bar and I get drunk and then I drive home from the bar and I run into somebody, well, it wasn't my fault because the government didn't hire me an Uber to take me home, right? People can be held responsible for the decisions or their failures to act that result in things like living indefinitely in public parks. And I think it's also important to say that we're not just talking about people who stay for a single day. We're talking about people staying in parks in tents for long periods of time. This Ninth Circuit ruling that said that it was cruel and unusual punishment to enforce these anti-camping laws created or helped to create a massive homelessness crisis across the United States, and particularly here in our hometown of Phoenix, Arizona, which decided, based on these rulings, on both the Martin and the Grants Pass rulings, that they weren't going to do anything about the homelessness problem. And in fact, they created an area called the Zone, where over 1,000 people at one point were living in tents on streets in downtown Phoenix through 120-degree summers during the COVID pandemic, because city officials thought that that was the more compassionate thing to do. So that question was obviously of great import, and it went up to the U.S. Supreme Court. And the Supreme Court in the Grants Pass versus Johnson decision overturned the Ninth Circuit's ruling and said it is not cruel and unusual punishment to arrest people under these circumstances. Now, here's how the logic of that works. The Ninth Circuit had based its decision on an old 60s Supreme Court decision that said you're not allowed to punish people for who they are. You can only punish them for what they do. So in that case, it was a rather odd law that made it illegal to be a drug addict, not to use drugs, but to be addicted to drugs. And the U.S. Supreme Court said that's irrational. That's cruel and unusual punishment. And so the question before the court in this case, in the Johnson case, was, is homelessness more like something, is that something people are, or is it something that they do? Is it like something they can't help? And the Ninth Circuit ruling says, yes, they can't help it. If the government doesn't provide them with a shelter bed, then they have to sleep outside. They have no other alternatives. which is really a bizarre, across the board, one size fits all rule that makes no sense and ties the hands of good faith government officials who want to try and deal with the homelessness problem, and provides a handy excuse to other officials in cities like in Phoenix who just didn't want to address the homelessness problem for political or ideological reasons. So the US Supreme Court says there's no basis in the Constitution for such a ruling, at least when it comes to the homelessness problem, and reverse that. Now, I understand the LA Times the other day published an editorial saying this case does not cure the homelessness problem. Well, the decision is not supposed to cure the homelessness problem. That's not what it's trying to do. What the Supreme Court was doing was removing an obstacle that the Ninth Circuit Court of Appeals had created in the way of trying to address the homelessness problem in our communities. There are as many solutions for homelessness as there are homeless people, because every case is different. Every situation is different. It has to be resolved on a case-by-case basis. Some people, maybe they need shelter for that night. Maybe they need drug treatment. Maybe they need psychological counseling. Maybe they just need a ride somewhere. Everybody's story is different. And the problem with the Ninth Circuit's ruling in the Martin and the Grants Pass decisions was that it created this across-the-board, one-size-fits-all rule. The U.S. Supreme Court, by taking that out of the way, is allowing communities to address this problem on a case-by-case basis. Homelessness is an ancient problem. The Bible says the poor will always be with us, right? This is not a problem that can be solved, and certainly not by government, but in some quick fix scenario. So homelessness can only be fixed by communities, by people like you and me, by community groups, by churches and other organizations that get together and try and help people out depending on their circumstances. And this decision allows for that to happen. So this decision, as Winston Churchill famously said during World War II, this is not the end. It is not the beginning of the end. It's the end of the beginning. And that's what this is. This decision is the end of the beginning. Again, the Goldwater Institute filed a brief, as many other organizations did, arguing in favor of the overturning of the Ninth Circuit ruling, and so we're really pleased to see that. I want to say, if you want to learn more about what the Institute is doing, both here in Phoenix and in courts across the country, with regard to the homelessness problem, please check us out on our website, because we have a lot of information there, including a brand new research survey that shows where the city of Phoenix was spending the money that was supposed to be going to homelessness aid, and how it spent enormous amounts of money and accomplished practically nothing. Also, check us out on the website to learn more about the ballot initiative that will be on the ballot here in Arizona at this coming election, to try and get hardworking taxpayers and business owners and homeowners in Arizona relief when the government refuses to enforce its own laws, as it did in the Zone case. John, let's talk about the next of the really big case, the case that really everybody was talking about, and not just legal nerds. I mean, this one really attracted attention from a lot of people who understand the dangers of the administrative state. I'm talking about the Loper-Bright decision. Why don't you talk about that?
Yeah, sure. I think it's important for folks that are on the call to understand the breadth of the administrative state in the system under which we're living. So, as a result of administrative rules and statutes, we live in a system where administrative agencies, which of course are staffed with unelected bureaucrats, get to develop their own rules, which have the force and effect of law, sometimes through a rulemaking process, sometimes through a less formal process. They get to investigate alleged violations of those rules using their own investigators. When an adjudication occurs regarding whether a violation of a rule occurred, it's heard in the first place by an administrative law judge who's hired by the same agency that wrote the rule and investigated the rule. And then importantly for this case, if somebody's subject to one of these rules, once it gets to a supposedly impartial court, an Article III court, courts are obligated, prior to this decision, to defer to the government's interpretation of a disputed statute or an arguably ambiguous statute. So that's pretty remarkable. You have a situation where administrative agencies are making the rules, investigating the rules, adjudicating the rules. Once you finally get your day in court, under what was previously known as, or under what was known as Chevron deference, courts were obligated to put their finger on the scale for the most powerful litigant in the country. the United States government. So that all came to be from a 1984 decision called Chevron, which said that if a statute is arguably ambiguous, and which statute is not, then courts are going to defer to the agency's interpretation of the law. So, for example, if the Clean Air Act says it's illegal to discharge, quote, pollutants into, quote, waters of the United States, what does that mean? Pollutants means whatever the agency says it means. Waters of the United States says waters of the United States means whatever the agency says it means, including a puddle in your backyard. So there's serious problems with that. Obviously, it creates due process problems for litigants, where when you appear, before a judge, you'd assume that both parties are on an equal playing field and one party doesn't get an unfair advantage. And then, of course, it creates separation of powers problems as well. Courts exist to interpret the law. I mean, that's their whole purpose, is to resolve these, what the law means and how it should be applied. And of course, it creates this issue where I think in many ways, the Congress and the legislature is incentivized to push things into administrative agencies to create more rules. And the agencies know that when they create those rules, they're not really going to be subject to a meaningful review, which of course has exploded, which has resulted in an explosion of agency rules. Tim, I don't know if you've looked this up anytime recently, but there's over 200,000 pages of federal regulations that exist in the United States today. By contrast, in 1960, there was a little over 20,000. And that's remarkable growth over a relative.
And these are rules that govern our lives that are not voted on and approved by our elected representatives. There's all this idea of how a bill becomes a law that you're taught in school, but the reality is that practically none of the laws that actually govern your day-to-day life are ever adopted in that way. They're adopted through these not just rulemaking procedures, but all these what they call sub-regulatory methods, like letters, and that a single bureaucrat sends a letter, and all of a sudden, basically, federal law changes.
Yeah, and then there's no way to challenge them, right? I mean, the bureaucrat. I mean, they literally get the last say, and they get to decide whether or not you're guilty. Yeah, it's remarkable, and of course, as a result of this, Chevron was massively consequential. It resulted in this explosion of the administrative state. The Chevron decision, at the time it was decided, it wasn't terribly controversial, or at least most folks didn't think it was going to be hugely impactful, but it has probably been one of the most impactful U.S. Supreme Court decisions of the last century. It's been cited over 18,000 times by federal courts in this country. So that's the background. The case that got up to the U.S. Supreme Court this term, in fact, it was two cases, a pair of cases, one called Loper-Bright and one called Relentless. They both involved a program of the National Marine Fisheries Service. And this program required that commercial fishermen carry federal observers on their vessels. And, oh, by the way, pay the costs of the federal observers. So that's pretty remarkable. This is the federal government telling a private industry that not only are you going to have regulators on your boat, literally on your boat, looking over your shoulder, but you're going to go ahead and pay the cost of that as well. And so those fisheries challenged this regulatory regime, goes up to the United States Supreme Court, and the U.S. Supreme Court says, nope, that is permissible, deferring to agencies' interpretation of the statute that was at issue in that case, does not comply with the Administrative Procedures Act, which says that courts are to determine questions of law. Justice Thomas also wrote in a concurrence that the regime that existed under Chevron deference violated, of course, core separation of powers issues, and the Supreme Court jettisoned Chevron deference. So massively consequential. I do want to note a couple things, and then I have a question for you, Tim. So now that this deference issue has been eliminated at the federal level, we still have a problem where about 36 states have applied their own form of deference to state agencies. And of course, state agencies are in many ways more consequential than federal agencies. I mean, obviously the Chevron decision, or the local Bright decision overturning Chevron, is incredibly important, but how many people really in their day-to-day lives are impacted by the Clean Water Act? By contrast, most Americans have to deal with a regulatory agency, an occupational licensing board. Maybe they have a land use issue, even family law issues involving state agencies that deal with adoption and things like that. So really, states are critically important here. And about 36 states have imported this deference doctrine into their own jurisprudence, or some have done it by statute. So we've done a lot of work in this area. The Goldwater Institute has, both on the litigation side and on the legislative side. We developed the first statutory reform in 2018 that eliminated deference to state agencies at the state level, and that's now been adopted by a number of states, including 3 this year. So I think those efforts will certainly continue into the years ahead. While I think Loper Bright massively important, we can't ignore the problem at the state level, and those efforts should continue. I want to ask you though, Tim. So Justice Kagan, in her dissent, of course, raised this specter of the sky is going to fall as a result of the Loper Bright decision. I think she characterized it as it's going to create a massive shock, her words, to our legal system. What do you think about that? What do you have to say?
Well, it's funny. I have been thinking about that in the past couple of weeks a lot, because you're right that on one hand, the Loper Bright decision is massively important, but on the other hand, that's not true. And what I mean by that is what the decision court says in this case is, look, the law is for judges to decide, but that doesn't mean that judges can't rely on expert witnesses, or can't say, well, I think the agency is right. Of course a judge can say that. And so that's normally known as Skidmore deference. It's a different kind of deference than Chevron deference. And all that Skidmore deference says, it's named after a case called Skidmore, of course. All that says is, if the court finds the agency's views persuasive, and the agencies, sometimes they really are the experts, and so the court should, should give weight to that. That seems like common sense to me. And when it comes to, like you mentioned, Justice Kagan, she uses this example about amino acids, and whether, should we classify them in this group or this other group? That's not something judges know, because we're not scientists and we don't know much about things like amino acids. Well, okay, but a judge can hear expert testimony from a biologist who can come on the stand and talk about amino acids and whether they should go in category A or category B. There's no reason that can. And so in that sense, this decision isn't that enormously important, because courts will still be able to use the tools at their disposal. But I think there's 2 things that are important about this case. One is the one that you mentioned, that courts are still in charge when it comes to legal interpretations, what the statutes mean. That really is the most important thing. But there's a broader sense in which this is important, I think, and that is as a symbolic thing. What this case really symbolizes, what it's going to represent, is it sends a message to the states, as you said, that they should rethink this sort of blind obedience to the ideas of Chevron deference at the state level. They shouldn't just mimic what federal courts do anyway. So it sends a message there. And it also sends a broader message that the idea of judicial deference is deeply misguided across the board. Unfortunately, a lot of my conservative friends have for years embraced this slogan, judicial restraint, that what we want is a restrained judiciary. We don't want activist judges. What the Chevron deference saga teaches us is that judicial restraint led to bureaucratic unrestraint, that tying the hands of judges just allowed the government to do whatever it felt like. Judicial restraint is often just a synonym for, if the government violates your rights, courts should do nothing about it. And that's why we at the Goldwater Institute have never been big fans of judicial restraint. There's a place for restraint, and there's a place for a court to act. What we don't want is a passive judiciary, a judiciary that just sits back and says, fine, government can do whatever it wants, we're not going to be active. We don't want that. That's not what the Constitution calls for. The Constitution calls for a tripartite system of government where each branch is a check and balance against the other to protect individual rights. And I think you're right, John, that this case really reiterates and really reinvigorates that principle, at least as a symbolic matter.
Yeah. In addition to this notion of judicial restraint, I think it also really strikes a blow to this Wilsonian notion that experts know best and experts are going to govern our lives, irrespective of what the people want and the people's elected representatives want.
Yeah.
That is, I think the pendulum is swinging in the direction of individual liberty and away from expert rule, in
I
large
think
part.
that's right. I think there are only three people in America, I think, who believe that experts should rule our lives, and that's Justices Elena Kagan, Sonia Sotomayor, and Ketanji Jackson. I think they're the only ones who think that experts should be in charge of everything.
And some of their friends in the lower courts.
Yeah.
I want to transition to the next administrative law case, but a quick note for our listeners. If you have any questions, drop them into the Q&A, not the chat box. We'll be able to see them that way. For whatever reason, they're not appearing on the chat box. So drop them into the Q&A. We did have a question that's relevant to this case, where Jolene asked what happens to existing regulations. Nothing in the near term, but when an agency attempts to enforce a regulation based on its interpretation of statute prospectively going forward, the agency no longer gets its thumb on the scale in court. So in that regard, a whole host of existing regulations that agencies will later attempt to enforce are going to be subject to meaningful judicial review. Tim, why don't you tell us about the Jarchesi case, the other important administrative law case?
Yeah, so this case involved the Securities and Exchange Commission, which is the administrative agency that's charged with regulating the purchase and sale of securities, stock market, that sort of thing. And this case really shows why what John was just talking about the administrative agency power to adjudicate and write rules and interpret them and apply them and this whole thing, why that's so crucial. In this case, the Securities and Exchange Commission claimed that this guy, Mr. Jarchesi, had engaged in illegal trading, and it could have charged him with fraud. And if it had charged him with fraud in a criminal trial, he would have been entitled to a trial by jury under the U.S. Constitution. But they didn't want him to have a jury. So instead, they accused him of a regulatory infraction, of violating an administrative regulation. And that meant that they could put him on trial in their own little in-house court, their administrative court, presided over by either a Securities and Exchange Commission employee or an administrative law judge. And the agency is really running the show in these administrative hearings. And this is, by the way, John, you mentioned that the states do the same thing as the feds do. This same thing happens at the state level all the time. And these administrative hearings, one of the big problems with them is that the ordinary rules of evidence and procedure don't apply in these administrative hearings. And very often the government will try and tell you that this is a good thing. They'll come to you and they say, hey, you have to come to this administrative hearing, but don't worry, you don't have to hire a lawyer. And of course, when you hear that, you shouldn't bring a lawyer. That immediately should set off the alarm bells in your head, right? But they act like this is a favor to you. Oh, you don't have to spend money on a lawyer to protect your rights because we're just going to violate your rights anyway, right? So the rules of evidence, like rules against hearsay and things, don't apply in these so-called informal hearings and things. Anyway, it's a problem at the state and federal level throughout, and plainly violates your right to a trial by jury. I mean, this is one of the most cherished, historically important, traditional constitutional rights that goes back to the American founding. And I by the way, I should mention my favorite current Supreme Court Justice, Neil Gorsuch, wrote separate opinions in both the Loper Bright case and this case. And they are masterpieces of legal argument. I very much encourage you to read Justice Gorsuch's opinions in both of those cases. They are perfect examples of why he was put on the Supreme Court. And he points out that, going back to the American founding fathers, this was a crucial point for Americans, that the British were trying to implement what was called at the time the Vice Admiralty court system. This was traditionally it had been reserved for cases involving cases that arose at sea on ships, and the British colonial authorities started forcing American colonists to go to these courts, even if the cases didn't necessarily involve something that happened on the high seas. And the reason why was because, first of all, you didn't get a jury. And secondly, the judge kept a portion of any money that he confiscated from you. Well, are you going to get an unbiased, neutral decision maker in that? I don't think so, right? That's not exactly a fair hearing. Today, by the way, we call that civil asset forfeiture. That's what that is. That we still do it today. It's a disgrace. And I encourage you to check out on our website at goldwaterinstitute.org the work that we've done in challenging civil asset forfeiture for precisely these reasons. Anyway, the U.S. Supreme Court in Mr. Jargazzi's case said this violated his constitutional right to a jury trial. Of course, the agency can't do that. Once again, provoking a dissent from the three liberals who think that it's fine for administrators to control our lives because they're the real experts, as opposed to us fools who are simply just going about our ordinary business paying taxes. Anyway, there's a quick rundown on Jargazzi for you, John.
Tim, but the dissent said there'd be more than 24 federal agencies that are now going to be handcuffed because they can't take money and civil fines and impose massive penalties on citizens without due process of law. What do you say to that?
John, I can never hear the phrase agencies being handcuffed without thinking of Thomas Jefferson in his book Notes on Virginia, saying that the purpose of the Constitution was to bind down, especially the executive branch, by the chains of the Constitution. That's the phrase he used. If you're putting chains on these executive agencies, that is what the Constitution is for.
Yep, I think that is a point that is often lost, especially on some judges in the federal judiciary. Tim, let's switch gears a little bit from administrative state to First Amendment cases.
Yeah.
A couple big ones. Net choice was a big First Amendment decision. Do you want to talk about that one?
Yeah, so the net choice case, it's actually two cases, one from Texas and one from Florida that got put together. By the way, one of my, as a legal nerd, I just love cases that have collective names like the slaughterhouse cases or the civil rights cases. I just love that. And so I like to call these the net choice cases just for that reason. So these are cases where Florida and Texas passed these laws that forced social media companies, and that's everything from Twitter and Facebook to, I don't know them all, Getter, Reddit, whatever it might be, to convey messages that they might disagree with and not want to convey. What it did was these laws, first they said that these companies are not allowed to remove a person's post or cancel their subscription without giving them a written warning and a written explanation as to why and allowing that person to respond. And then these laws prohibited the companies from removing any posts by so-called media companies, which the statutes then defined that term as meaning organizations, even a blog that gets 10,000 readers or more, I think it was. So the reason behind these laws was this feeling among the conservative world that Facebook, Twitter, and these other companies are blocking, or as they like to use the term, censoring their posts and their statements. Now, as we said in our brief that we filed in the case, we have experienced this ourselves at the Goldwater Institute. Facebook, in particular, has sometimes either outright blocked or has diminished the accessibility or the viewership of things that we have tried to post on Facebook, which are perfectly innocuous, ordinary kinds of political or legal arguments that people ought to be informed of, and that we hope will persuade them. That's perfectly legitimate for us to post that, and that's been a hindrance to us in getting our message out. Nevertheless, we respect that Facebook and Twitter and these other companies are private businesses, and they own private property, and these companies are their private property, and they also have free speech rights. So they have a right not to convey messages that they find offensive or obnoxious. And there's nothing constitutionally wrong with that. If we don't like that, we can take our business elsewhere. Now, I've heard a lot of people say, well, you can't really take your business elsewhere because these companies are so big, you can't really compete against them. Well, tell that to former President Donald Trump. When he was blocked from Twitter, he turned around and started his own company, Truth Social, which he still uses to this day. And then there was Parler, which was another competitor to Twitter. It failed because people chose not to obtain its services, just like any other business might fail in the marketplace. And by the way, it has now come back. It has just relaunched recently. then there's plenty of other options out there to get your word out. So the idea that these companies are somehow monopolies is really rather foolhardy. So we filed a brief in their defense saying, yes, we've been harmed by their policies and we think their policies are wrong, but they have the right to make those decisions for themselves because they're businesses with free speech and private property rights. And in particular, we argued that the Supreme Court should overrule an old case from the 1980s called Pruneyard, in which the California courts said it was perfectly fine to force the owner of a shopping mall to allow people onto this property in order to make political speeches, even though that person didn't want that. And the U.S. Supreme Court was okay with that also. Unfortunately, the U.S. Supreme Court in this case did not address that question, did not talk about the Pruneyard case, which is very unfortunate because it was wrongly decided and it was really foolish and has even been abandoned largely in California itself. But what the Supreme Court did say is it said, look, there's not a lot of facts here. We aren't comfortable issuing a final decision. We want there to be a trial. So they sent the cases back to trial court to resolve some of the factual disputes. But along the way, the court said, these are private businesses and they do have free speech rights. And you can't just come in there and take away their free speech rights in order to, quote, balance the messages that are being expressed on one service or another. That's not the role of the government, and it violates the First Amendment for the government to do that. So I think that was a big victory for free speech and an important signal as to how free speech is going to be applied in our digital age, when it seems like so much is going on, so much being argued about and decided on these social media companies. On their business, on the platforms. I do think it's important to remember whenever we talk about these cases, though, that actually a very small fraction of Americans are using Twitter daily or Facebook daily and arguing about, some obscure political issue on Twitter. They aren't. It's actually a rather small number of people who are doing this. It's easy for those of us who do this for a living to get sucked into the idea that everybody spends their days arguing about legal or constitutional issues. It's not the case. So we shouldn't freak out is my message there.
It does go to that point too about the sort of too big to fail almost.
Yeah.
It always comes up throughout history, right?
Oh yeah, remember, John? You remember that the cover story of on the cover of Forbes about how Nokia cell phones had a monopoly and could not possibly be beaten, or the Guardian article that said MySpace is a monopoly and can ever be overcome, and who uses
the great A&P book you recommended, the biggest store in the United States. I mean, it always comes up. And of course, the only monopoly are government created monopolies.
Yes, and that I'm glad you said that, because that points up an important point, which is a good free marketer always asks, what are the alternatives here? Remember, the great Thomas Sowell likes to say, there are no answers, there are just trade-offs. So the question isn't, is Twitter a well-run company? The question is, do we have any reason to believe that government will do a better job of it? That's the real question. And the answer to that is emphatically no. There's no reason to believe that the government can be trusted with the power to decide what kind of messages need to be emphasized more or need to be de-emphasized more. Skepticism toward the government, it would be nice to see a little bit of that from time to time. And I'm glad to see that the U.S. Supreme Court is at least still skeptical, at least in this regard.
Well, hey, I'll chat about Vulo, because I think a lot of our listeners are going to be interested in that. Another very important First Amendment case.
And also, John, it's a case that really points up to what we were just talking about the dangerous power of government.
Exactly right. So the facts on this one are really, really interesting. There's a New York financial regulator named Maria Vulo. And she ran a department called the Finance Services, the Department of Finance Services. And among other things, that department regulated insurance companies in New York. Now, like a lot of federal agencies, like we were talking about earlier, it has tremendous power. It could initiate civil actions. It could refer criminal charges, among many other things. Meanwhile, the National Rifle Association, the NRA, of course, operates throughout the country, including in New York. And the NRA had contracted with a number of insurance companies, one of which was Lloyd's of London, but it was several of them, to offer insurance policies as a benefit to its members, including some insurance policies that provided protection from liability for firearms incidents. So Ms. Vullo didn't particularly like the NRA. She was outspoken about her anti-gun views and her desire for firearms control. And so she told financial regulators in the state of New York that, maybe you all shouldn't be doing business with the NRA. And then, in fact, in 2018, she met with executives from Lloyd's, and she told them, senior executives, and she told them in this meeting that she believed in gun control, but she would be, quote, less interested in pursuing infractions that company might have committed, infractions unrelated to the NRA, so just other activities that the business was engaged in, so long as Lloyd's ceased providing insurance to gun groups, including the NRA. So here you have an extraordinarily powerful regulator telling one of the entities that it regulates, hey, we might look the other way on some things we can investigate regarding your company, but we're only going to do that if you don't do business with the NRA. And then subsequent to that, she sent out a letter essentially encouraging Lloyd's and other insurance companies to reevaluate their relationship with the NRA. She had a big press release with the governor at the time that sort of reiterated these points. So the NRA sued, and they said, hey, look, this regulator, Ms. Vullo, has violated our First Amendment rights because she's coercing other parties that she regulates to terminate their business relationships with us. Now, remarkably, the Second Circuit said that that was okay. They said that Ms. Vullo was really just trying to persuade these companies, and she was just carrying out her regulatory duties in doing that. Case makes its way up to the United States Supreme Court, and in a unanimous decision, interestingly, authored by Justice Sotomayor, the court found that the NRA had, in fact, alleged a First Amendment violation when this regulator coerced entities that were regulated by her to cease doing business with the NRA. And she said, the court said through Justice Sotomayor that the regulator's actions are reasonably understood as a threat of adverse government action in order to punish or suppress the NRA's gun advocacy. So consequential decision for the First Amendment, very clear. The government cannot use its regulatory might to try and coerce private individuals from engaging in private conduct and private speech. Now, interestingly, this came up, the posture in which it came up was on a motion to dismiss. And what that means is that none of the facts have really been fully developed. The case was dismissed only after, in this case, the NRA filed its complaint. And when that happens, you have to take all of the factual allegations as true that the NRA alleged. So this case is now back on remand in the lower courts. And there was a somewhat disturbing footnote. This doesn't impact the First Amendment importance of the case, but the court said, hey, we're remanding it. And nothing in here that we've been talking about will prohibit essentially this regulator to argue that she has what's called qualified immunity from civil liability. Tim, do you want to talk about that for a second? What this notion of qualified immunity is and why it might be a problem?
Yeah, qualified immunity has been a sort of a thorn in the side of really anybody seeking justice for those abused by the government for decades. Qualified immunity is a judge invented doctrine that says that even though federal law says you can sue state officials for violating your constitutional rights, nevertheless, the court is going to say you can't sue these officials for violating your constitutional rights unless they really knew what they were doing is wrong and really did it, really knowing that it was wrong. And as that suggests, the standards for this kind of immunity are so squishy that it's virtually never possible for you to overcome them. The way it works is this: the court says you can't sue, let's take, for instance, a police officer who searches you without a warrant, for example. You can't sue the police officer for that unless you can show that the police officer violated a clearly established constitutional right, the right not to be searched without a warrant. But the term clearly established constitutional right means like there has to be a court case, a court decision on that particular topic. And since, of course, police officers deal with all sorts of different circumstances on a daily basis, then there never is a case that's directly on topic. For example, there was a case a while back where a defendant who, I guess he was out of his mind, covered himself in gasoline. The police officers pulled out a taser and shot him with it, knowing that he was covered in gasoline and that shooting him with the taser would cause him to burst into flames and die. And they did it, and so his survivors, his family, sued. And the court said, well, there's no case directly on that point. I mean, that's the sort of thing, if you violate, well, yes, it's true. That previous case said you're not allowed to do this, but that happened on a Tuesday, and this case involves a Monday. I mean, it gets into that kind of absurd kind of hair splitting.
Well, what about that case? What about that case where the police officer stole money, literally stole money, and admitted to it, but then there was no civil liability because
that's exactly right. A case that's going on right now, and that in fact we're going to be filing a brief in fairly soon. The second point of this is that this doesn't just apply to police officers. I mean, the idea originally, I think, was supposed to protect the cop on the beat who has to make a split-second decision that maybe is the wrong call, right? That's the idea behind this doctrine. And okay, fine, whatever. But the problem is that it's been applied way beyond that to things like teachers who follow school policies that are unconstitutional. And the court will come in and say, well, it wasn't clearly established. Well, there's no split-second decision there. That's something that happened over a long period of time. And so it's irrational to apply this qualified immunity doctrine there. And so we and our sister organizations across the country have been trying to push back against this qualified immunity doctrine. And I think we have been making some progress. There are some judges who have expressed a lot of skepticism about this qualified immunity doctrine. But so far, the U.S. Supreme Court has shown no inclination to try and go in there and fix the mess that really it made, because there's nothing in the actual statutes, nothing in a law that Congress passed that creates this kind of immunity. It's entirely manufactured by the courts, and of course that means only they can possibly get rid of it.
And of course, like so much of the other work that we do, there's state solutions to this.
Yes.
And I want to make one point in that regard. So we do a lot of work at the Institute involving state constitutions, right? I think a lot of people in this country believe there's only one constitution, the United States Constitution. But of course, there's 51. And that's critically important because state constitutions, even when there's similar provisions, things like free speech protections or right to bear arms or due process protections, even if a state constitution has a similar provision like that than the United States Constitution, the US Constitution is just a floor to the protection of individual liberty, and courts can go above and beyond in protecting rights. And in fact, for example, Arizona's Supreme Court has said that our free expression provision can be interpreted more broadly to protect individual liberty. And then, of course, there's a whole bunch of provisions that exist in state constitutions that have no analog in the federal constitution, anti-substitute.
And this also brings up another important point, John, which is that federal courts do pay attention to what happens in the states, and that can influence their decisions. We were talking earlier about the Loper-Bright case overruling Chevron. The brief that we filed in that case pointed out how many states, led by Arizona, have chosen to abolish their state-level versions of Chevron deference to state agencies. And it turns out that all hell has not broken loose, that these states have not turned into wastelands from, Mad Max Beyond Thunderdome or something. They're still able to enforce their laws, and it's been just fine. And that question actually came up during the oral argument. In fact, Justice Kavanaugh specifically asked the government's lawyer to respond to this question about the states that have abolished their versions of Chevron deference. Everything's been just fine. So the point is that the state level work that we like to focus on does have this influence on the feds, and should, because if you think about it, a lot of the states are older than the federal government, and their constitutions are older than the federal constitution in some cases. And so it should be that the feds are looking to the states for guidance. Unfortunately, what you often find is that state judges look to the feds for guidance. And so what you end up with are sometimes totally irrational court rulings where state judges will copy something a federal court said in like 1930 and use that to interpret a different constitutional provision in a state constitution that was written in like 1890, which doesn't make any sense at all, right? All that is frankly intellectual laziness on the part of a lot of state courts, and unfortunate. But I think we're making progress in persuading courts to be more attentive to state legal and state constitutional issues.
Just a reminder, you got a question, drop it in the Q&A box. We got a couple here. In fact, these two are somewhat related. Larry asks that the Biden administration has failed to follow judicial rulings when inconvenient, and what are the consequences when that occur? Well, I mean, the government in all administrations oftentimes can be like a river. You put up a rock and then they just attempt to flow around it. But I think this question,
that would be the river Styx, right? Or the river Acheron.
That's right. But this does put a point on the importance of decisions like Loper Bright, where the government is not going to get a pass as often as federal courts and in a lot of state courts have given them when important decisions like this issue. And if they try to get around the law by promulgating a rule based on some ambiguous statutory provision, or they try to encroach on the powers of Congress, or try to get deference from a court, those things are going to be less likely to happen when decisions like Loper Bright issue and the judiciary does its role of holding the popularly elected branches accountable.
Yeah, in fact, I think Professor Cass Sunstein is a very prominent administrative law expert. He just published an article this week saying that he thinks the biggest effect that Loper Bright is going to have by overturning Chevron is that it's going to dissuade these agencies from even trying what he likes to call adventuresome interpretations of federal law. And that's great. There's an old saying that that in the intelligence community, that you never hear about it when they do a good job, because the whole point of what they do is to be secret, right? And it's the same kind of thing when it comes to constitutional law. We have to remember that success often consists of the government not doing things in the first place because it knows that it can't get away with them. And you particularly often encounter this, where you've often had situations where you'll send a threatening letter to the government and say, hey, what you're doing here is illegal, and they'll back down. And you and I kind of get a little frustrated at that sometimes, because we'd like to go to court and sue them over it. But it's a good thing that they back down and they follow the law. That's how the system is supposed to work. Ideally, your constitutional system is going to work by there's never any illegal action by the government because they follow the law. That's ideal. So sometimes our successes don't come in the form of major court victories. They come in the form of a controversy never arising in the first place.
Yeah, no, that's a good point. And I think you basically answered this. Matthew had a question along these lines. What are some of these partisans, these unelected regulators that the agency's going to do to get around? In this case, he asked Congress, in light of some of these rulings. And well, I think the first consequence is, I think they're going to do a lot less than they have up until this point. I mean, when you live in a system where none of their actions are going to be subject to any meaningful review, and you now have a system where they're going to be, I think you're going to see a lot less rulemaking, a lot less arbitrary decision making, and maybe them bringing investigations or cases that they knew to be borderline won't be brought. Now, regulators are clever and they're going to find ways.
I was just going to say that's the optimism that we all love you for, John.
Well, let's hear the pessimistic stuff.
Well, I just the bureaucrats are like the broom in Fantasia, and the part where with Mickey Mouse, and where you chop up the broom into little splinters and then they just turn into more brooms. Bureaucrats are kind of like that. So look, and I say that that is entirely intended as a joke. And the reason I say that is because our problem is not bad bureaucrats. The problem is not corrupt or foolhardy bureaucrats. That can be a problem, of course, but the problem actually is much more conscientious and hardworking bureaucrats. And most government bureaucrats, federal and state, are conscientious and hardworking. They're trying to do their job as they see it. And their job is to enforce the regulations and the laws that they're given. And that naturally, they're going to seek to expand their power in order to do what they think is in the public interest. The problem, of course, is that the Constitution is there to protect us against conscientious bureaucrats who are doing just that. The Constitution exists to protect us against people who think, and maybe in some cases with good reason, that they know how to run our lives for us, because there are other values above and beyond efficiency that our Constitution is supposed to protect. It might be perfectly efficient to it would be more efficient, honestly, to get rid of the warrant requirement and make everybody's house subject to search at any time, right? You could probably eliminate a lot of crime by doing that. But of course, you would also eliminate privacy by doing that. And so our Constitution purposely blocks certain efficient things for that reason. And in the same sense, it blocks efficient bureaucracy because there are other concerns, especially democratic concerns. I think we may have overlooked mentioning how important a democratic decision Loper-Bright is, that these laws, because they're passed by people who are not elected, that means that the laws are undemocratic in that sense. And by returning that power to Congress and to the people, the Loper-Bright decision is a win, not just for freedom, but for democracy. I think that's really important to emphasize here.
That's a great point. Well, Tim, we're coming right up about on the hour. Any predictions on big issue areas to be on the lookout for next term, and any final thoughts on the consequential cases from this one?
Yeah, well, the court just granted review in a case that promises to be very interesting about, and it involves administrative agencies like we're just talking about the FDA's regulation of vaping products. These are devices that help smokers quit smoking, right? The vaping pens that people use, and it makes the steam and all that. The question is whether the FDA has the authority to regulate them in the way that it claims to. And that's another one of these administrative agency decisions. So that looks like it may be the next step in this effort to try and rein in the out of control bureaucratic state. I think that's a case that I'm particularly keen to see how it comes forward. Having said all of that, I want to reiterate for our audience to keep an eye on those state courts. We've got a lot of really interesting cases going on in state Supreme Courts and state lower courts, both in Arizona and in other states. And it's really worth keeping an eye on. You just got a really great decision from the Texas Supreme Court in a case challenging government subsidies to government unions, for example. Congratulations on that. And we've got decisions coming in the Arizona Supreme Court and in trial courts across the country about our effort to defend individual freedom, both against bureaucracy and against wrongful school officials and other kinds of government entities.
Well, I want to thank all of our listeners for joining us this morning. I think it's been a really good conversation, and it's always good talking with you, Tim, the nation's subject-wide expert in so many of these areas. Appreciate all of our supporters. Again, if you want to follow the work that we do, both the litigation and legislative and public policy research areas, please go to goldwaterinstitute.org. Tim, any final thoughts before we sign off?
No, I guess that wraps it up. There's all sorts of good Supreme Court cases on the horizon. Oh, there's the Hawaii gun case. We didn't talk about that. That's coming. There's all sorts of fun stuff. The Hawaii gun case, just really quickly, is a case where the Hawaii Supreme Court said, well, the Second Amendment doesn't really apply in Hawaii. And so we'll see what the Supreme Court does about that. It's refreshing to see the Supreme Court taking Second Amendment issues seriously, which they didn't do for a very long time. And now the court is more attuned to protecting that right. Anyway, so there's lots of issues out there. Please keep an eye on our website, goldwaterinstitute.org, and our blog, which we update regularly, as well as our video and audio feeds to follow the work that we're doing in courts and legislatures across the country to help people live freer and happier lives.